So who was here last year? And now can you hear me in the back? Okay. So who remembers the declarations and preamble section? Okay, we have Reverend Kraft. You do? All right, good. So what we did with the Declaration and preambles is we talked about the principles that were built into the Constitution, and that was meant to be a tool for you to use, and we're going to use that tool here. Use those tools everywhere in your life. Is it true? Is it supported by natural law? Is it in conflict with or congruent with God's Word? Everything good and true will line up with God's Word and with natural law. So, I'm only going to be hitting high points. You're going to have work to do on your own to go through and look at things and think about things. Because if I tell you, you will not know. You will merely have been told. Think about them for yourselves. Work on them for yourselves. Or else you will not know this. So the Declaration of Independence and the preamble to the Constitution, they tell you what the founders were trying to do. What were they trying to do? Build a government that protects rights, that protects liberty. Those were the principles they were trying to build on. But also keep in mind, where were they in 1789? Yes, they were in North America, not physically. Where were they intellectually? What was the geopolitical realities around them? What were the pressing issues? What influenced their thinking? 1787, the summer the Constitution was written, was only 4 years after the Treaty of Paris that officially ended the Revolutionary War. They were 10 years into a federated government under the Articles of Confederation that was falling apart because it didn't have enough power to actually function. Their former enemy, Britain, and their former allies, France and Spain, were kind of circling like vultures, just waiting for these little upstarts to collapse, because we had an entire continent full of amazing resources that once we collapsed, they could swoop in and take. Well, they didn't really want that, did they? So keep all these things in mind when you read and when you analyze the Constitution. And also keep in mind whenever you hear criticisms of the Constitution, who benefits? Cui bono? Who benefits? So, we're going to talk about the Bill of Rights this morning. We'll talk about Articles 1 and 2 this evening. So the principles in the Bill of Rights, right? Declaration of Independence set those forth. That rights are not a gift of the king. They are an inherent gift of God. Is this still working well enough? All right. The proper function of government, civil government, is to protect and secure the rights given to the people by God. That's its purpose. The people then also have the duty to be the watchdogs over that government they've created. And that the just powers of government support the essential function of safeguarding those rights. Not your stuff, not outcomes, safeguarding the rights of the people. The preamble to the Bill of Rights says, the conventions of a number of the states, having at the time of their adopting the Constitution, expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added. So that kind of plain talk can only be misunderstood by professors of English and lawyers. Right? What's the purpose there? Further declarative and restrictive clauses should be added. So first of all, there were already declarations and restrictions, right? And they want more. What are they trying to limit?
The power of government.
The power of government. Exactly. The entire purpose of the Bill of Rights is to put further restrictions on the lawful constitutional actions of the federal government. You can't do this, don't touch that, keep your grubby mitts off, don't even think about it. That's what the Bill of Rights is. So all rights are based on property. All of them. Starting with the first piece of property you ever own as of the day you're born. What is that? Your own body. If you don't have the ability to determine what happens to your own body when you are an adult, what are you? You're a slave. As a child, you still can determine a lot of what happens to your body under the control of your parents who are responsible for you. But the first piece of property you ever own that you are ever responsible for is your own body. So all rights derive from property. So when we go through the Bill of Rights, when we go later through the Constitution, keep an eye on how the entire structure of the documents protect property. The Bill of Rights also express some specific problems that were listed in the Declaration of Independence and problems that cropped up during the federated government under the Articles of Confederation. Amendment number 1. Congress shall make no law. And Michael Badnarik, the 2004 Libertarian Party candidate for president, always says, what a shame they just didn't put a period there and be done. Congress shall make no law. We're done. But that level of wisdom or foolishness was not granted. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. That's the entire text. Again, we have real simple language that only English professors and lawyers can't understand. So what's Congress? What is Congress? The House and Senate, the representatives of the people, and as originally constructed, the representatives of the states. Because the Senate was originally supposed to be the ambassadors from the sovereign states to the federal government. So at what level of government does Congress operate? That's the federal, it's not the states, right? States have their own legislatures, etc. But Congress is the federal level of legislature. What did every state have in 1789 when the Bill of Rights was ratified? They had a state religion. They had an official state religion. In Pennsylvania was the Quakers, and someplace else it was the Anglican Church, and then there was the Episcopals, there was the They all had an official state church. So the First Amendment prohibits the federal government from establishing a religion. So what does it mean to establish a religion at the federal level? What is an established religion? It's backed by the government. It's supported by tax receipts. Attendance likely is mandatory. Its membership is likely required for privileges in voting. That's an established religion, and that is what the federal government is prohibited from doing. Does that mean that they can't allow a town to put a nativity scene on the town green? It's ridiculous. That comes under the next part. Free exercise. What's the difference between establishing a religion backed by the government, supported by taxes, with mandatory attendance and membership requirement for voting, and putting a menorah or a nativity scene on the town green? Huge difference. But think about these things. So what is free exercise? Does it just mean that you have the choice of what building you're going to on Sunday or Saturday or Friday or Tuesday night or Wednesday night? It's a lot more than that. Does free exercise also involve actions? If your faith says that gay marriage is wrong, can you refuse to make a cake for a gay wedding? Or print the wedding invitations? Think about it. free speech is protected. So, what's protected? What kind of speech is protected? If I say, it's hot and sticky today, does that speech need protection? No, it doesn't need protection. How about if I say the sky is blue? That doesn't need protection. The only speech that needs protection is speech that could offend. Speech of political disagreement. That's the speech that needs protection, because if you cannot disagree with the government, you have no right to free speech, and you can't protect your own rights, starting with property rights to your own body. If you can't stop the government by talking, at some point it ends up shooting. Is there a right not to be offended? No. When I was a kid, they used to say, sticks and stones will break your bones, but names will never hurt you. Well, names did hurt, but you got a thicker skin. And nowadays, when people call me names, and for my political views, racist, sexist, homophobe, Islamophobe, antiphobe, whatever, it just makes me laugh, because they've proven that they know nothing about me. But without being called all sorts of nasty, rude names when I was a kid, it might bother me a lot. There is no right not to be offended, and as much as it's not fun to be offended, it can be very useful. But here, there's a type of speech that isn't protected. It's called fighting words. There is actually a legal definition of fighting words. And those are words that are an immediate invitation to violence. Antifa, yes. It's very closely related to fighting words. What's incitement? Is incitement protected? Both of these two, the fighting words and incitement. I'm not a lawyer and I don't play one on television. But if you say things that incite violence, in law, that is considered assault. You can be arrested, you can be prosecuted. So, incitement and fighting words are not protected. They are actually actionable under the law. That's vastly different from saying, I think our president is doing a fabulous job. That's not incitement. That may be offensive to someone, but that is not incitement. Anything that Antifa says, we're going to come protest and bring your guns, like they just did in Portland, that's incitement. That's actionable. What about commercial speech? Commercial speech is not necessarily protected. How about obscene speech? That's also not necessarily protected. Where's the line? How was free speech disseminated in 1789? People stood on a soapbox in the town square, or they just stood in the town square or in the local pub, or up at church, up in front at church on Sunday, or in town meeting, or they published in booklets, pamphlets, broadsides, etc. Extrapolate that to today. How does speech from the public get disseminated today? Is free speech protected on those platforms? And what's a free press? And what's the difference between a free press and a propaganda machine?
Fake news.
Yeah. And the right of the people peaceably to assemble. So what kind of assembly is protected? It's a peaceable one. Does that include Antifa? Does it include people standing with signs praying? Does it include riots? Does it include blocking roads? Would there be proper redress by lawsuit if the road is blocked by protesters and you can't get someone to the hospital and they are permanently injured or die? one petition the government? You just sign a petition, send a letter to the president or the Congress, file a lawsuit, hire a lobbyist. And are your faith and your other opinions part of your intellectual property? Because not all property is physical. Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What's the definition of to regulate in 1789? Not today, because today that word has changed meaning to mean micromanaged to within an inch of its life. But in 1789 it meant to put in good order, as to regulate the disordered state of a nation or its finances. So a well-ordered militia is one that trains regularly. And who is the militia? The militia of a country are the able-bodied men organized into companies, regiments, and brigades, with officers of all grades, and required by law to attend military exercises on certain days only, but at other times left to pursue their usual occupations. So, military trained, not full-time soldiers. Both of these definitions are from Webster's 1828 dictionary, which is available online at, surprisingly enough, 1828dictionary.com. So why is a militia and not an army necessary to keep a state free and secure? The government controls the army. And remember, in our definition of militia, at other times left to pursue their usual occupation. So these are guys that just live and train near home, who are going to be more interested in protecting their families, their towns, and their state than obeying a faraway government that tells them to take up arms against their families, towns, and state. So that's why a militia is necessary. And when we get into Article 1 of the Constitution later, we'll see another aspect of this. The right of whom to keep and bear arms? The right of the state, the right of the militia, the right of the army, the right of law enforcement, the right of the National Guard, the right of the people. The people, and no one else. What arms did the Revolutionary War soldiers have and use? What did the British regulars have? Then muskets. They fought in squares, as they had been trained, that worked in Europe. The militia that turned into the Revolutionary War Army were all privately owned arms. You brought your own rifle or musket or whatever you had to train with. And for the most part, it was rifles, because people whose lives and safety and being able to eat depended on what they could catch, they wanted the best. So the arms were owned by the individual soldiers. Surprisingly enough, so did most of the artillery used in the Revolutionary War, was privately owned. Either the rich family of a town would buy a cannon, or people would band together and then the town would own one, but most of the artillery used was also privately owned. What does shall not mean? Don't. This is one of those areas of don't touch it, don't even think about it, keep your grubby mitts off. No. No. Ask any 2-year-old what no means. No. Shall implies a promise, a command, or determination, and implies authority to enforce the act. So shall not implies the power to enforce the shall not. And the power is exercised by those holding sovereign power, which is the people, who are also the watchdogs, except we fell asleep. So what does this have to do with hunting? What does it have to do with self-defense other than obliquely? Is the state of which you are a citizen part of your property? If so, it's also your responsibility. And what is the ultimate enemy that the Second Amendment is designed to protect the people from? The government, the federal government, should it turn to tyranny. 4 years after the Treaty of Paris, when a citizen militia turned ragtag army won a victory over the best trained army on the planet, were they going to make any rule that allowed a future government to do what the British regulars couldn't do, which is to win over the people? Duh, no. It cost years, it cost lives. They were not going to make doing that again any harder. Amendment 3, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Why was this added? What did the quartered soldiers do? Yes. Speak up, please. I'm sorry, this fan's. I still didn't hear you. Oh, they were far worse than rude to the people who were housing them. They would kick the people out of the houses to go live in the barn. They'd slaughter the cow, cut up the furniture and use it for firewood. There were all sorts of predations. So, who cares today? Why should you care? What do all these amendments do? They protect property. What kind of property is protected here? Your home? Your right to use your home and live in your home and determine what goes on in your home. Amendment 4, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. There's that shall not again. And no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So there's an emphasis here on protecting personal property. We're not going to go through it. Sometime you go through and look at the list of the types of personal property being protected. Tangible property, intellectual property. What's the principle behind this? Protection of property. So does that principle then apply to modern types of property, like email, like phone calls, like posts on social media? Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or, what's the magic word here? Property, without due process of law, nor shall private property be taken for public use without just compensation. That's a biggie. So we get the Miranda warning and the phrase taking the fifth from this amendment. But are those really the most important parts of the Fifth Amendment? I propose that those are the minor parts of that amendment. So when's a grand jury required? For a capital or infamous crime. Why that level of crime? What's a grand jury as opposed to a petty jury? These are things for you to look up and think about. These are important, and you need to know them. But if I tell you, you will not know, you will merely have been told. Why are the military and the militia not covered by this amendment? Did they go unpunished if they commit crimes? No, there's a code of military justice. They were exempted for a purpose. Double jeopardy and self-incrimination are prohibited. Why? Why shouldn't you be able to try somebody twice? Keep trying them until you get the verdict you want. Why shouldn't you be able to force someone to testify against themselves? Why? And what is due process of law? And how does it protect life, liberty, and property? Due process of law is a specific phrase. It means specific things. It means warrant, proper search that's legal. It means trial by jury, advice of counsel, ability to defend. There's a very specific meaning to due process of law. With that in mind, think about how it protects life, liberty, and property. And then define just compensation and how you can determine it. What circumstances justify taking private property for public use? Increasing the property tax base, public safety, defense, trade. Where's the line? How much emphasis should be placed on alternate locations or options before taking private property? Amendment 6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Protection of life, liberty, and property, property, property. Why should a trial be speedy? What does it matter if it's delayed 3, 4, 5 years? Why should it be public? Why should it be in the same jurisdiction? Why do you have to disclose the nature and cause of the accusation? Witnesses for and witnesses against. Why? What is counsel? And why might it be a good idea to have it? Anyone have comments on anything here? Lots of things to think about, and they all feed into protection of rights and property. And a lot of these have to do with problems that arose under the Confederated system or under the British system. Amendment 7. In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. Why $20? I mean, that's only a half a bag of groceries today. But in 1789, the average annual wage ranged between $120 and $250. So what percentage of your annual income was 20 bucks? And it was not a huge amount, but it certainly would have taken a bite out to lose that without recourse. And what's the difference between courts of law and courts of equity? Because that's mentioned a couple times in the Constitution. What is that? A court of law is where there's black and white rules, statutes. Yes, you ran the red light. No, you did not run the red light. Contract. Yes, this person violated the terms of the contract. No, they did not. A court of equity is more concerned about fairness and equality, family law, probate, bankruptcy. Be aware of the difference and look for where it shows up in the Constitution. Amendment 7. What does it mean today that no fact tried by a jury shall be otherwise examined? Does that a little feed into like the double jeopardy and being tried twice? But this is about property rather than breaking a law? Or is it something else? And how much power does a jury really have? In fact, in law, in application of the law, juries are actually the last gasp defense of the people in the courts against laws that are unconstitutional, unfair, being applied incorrectly, being applied punitively, being applied for political reasons. The jury has an amazing amount of power, and the Fully Informed Jury Association will be very happy to provide you with all kinds of information about that. So, knowing how much power a jury has, you can see that somebody is completely guilty of what they've been charged of, but the law was not applied properly, or the law is being applied only because of their political orientation, sexual orientation, color of their skin. You can still find them not guilty. You can find the law wrong and toss the law. Who doesn't want you to know this? And why? And the effort they spend to stop you from finding the power of a jury tells you how desperate they are for you not to know and how much power you have. Yes, sir?
How does the jury pass the law?
By finding that the law is unfair, unconstitutional, misapplied. Is that if they find the law unconstitutional, they can say this law was unconstitutional, therefore null, void, and of no effect. If they find it's been applied inappropriately, they can say this law has not been applied appropriately in this case, and therefore there is no conviction under this law because it should never have been applied this way. Amendment 8, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So what's bail? Why do we have it? Who does it protect? And the interesting thing here is that bail protects the accused and the state, or federal. It's a promise, money you pay in order to be free until your trial. And it protects the state because it's going to be high enough to make sure you show up, and it protects you because you're not stuck in jail while your crops go to rack and ruin while you're waiting for your trial. But is it required in all cases? Excessive bail isn't defined. So what's the bar? What if you're poor? Should the bail amount be up here? If you're rich, should the bail amount be down there? Should that bar go up, depending on how serious your crime is? And if your crime is very serious, at what level do you refuse to give bail? Because the person's a danger. Cruel and unusual punishments are prohibited, but what was considered a usual punishment in 1789? Public floggings, stocks, hangings, fines. So, knowing what was considered usual punishment in 1789, would the pink jumpsuits being the inmates in Arizona being forced to wear that they went to law, they sued over having to wear them, would those be considered cruel? Putting some mean MS-13 thug in a pink jumpsuit, is that cruel? Should we weep for him? Amendment 9. The enumeration in the Constitution of certain rights shall not, don't, hands off, shall not be construed to deny or disparage others retained by the people. What concerns does this amendment address? One of the big concerns that a lot of the states had before they agreed to ratify the Constitution was This doesn't give a list. How do we make sure that the government says, well, there's no list, so we'll just start meddling? And this amendment says, there's rights we haven't listed. Keep your grubby mitts off. So what might be some of those other rights that are retained by the people? You think about them. But would those additional rights include anything that could harm someone else? Would those additional rights include redefining biology, redefining marriage, or redefining consent, now that they're talking about normalizing pedophilia? What's the age of consent? Can you redefine that? If not, then where and how do we protect the personal rights of the tiny minority of people who might be affected? Think about that. We don't have the right to redefine marriage. So then how do you defend the rights of gay couples in civil law? And where's the line between the right of an adult to choose the course of their own life and when that person constitutes a danger to themselves or others? You've got a Jehovah's Witness who doesn't believe in blood transfusions, and there's a car accident and their kid is badly hurt. Where's the right of the state to step in and say, the child cannot make the decision, and your decision puts the life of that child in jeopardy unnecessarily? Where's that line? I'm not telling you where it is. Think about it. Amendment 10, last of the Bill of Rights. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. All not surrendered is retained. Madison said if the power was not given, Congress could not exercise it. The powers of the federal government were supposed to mainly be looking outward, internationally, and a few places where it dealt internally. The states had the responsibility for dealing with the day-to-day civil polity. And the people retained all the rights not necessary, not ceded to the state or federal governments. This amendment was invoked very frequently to curtail the powers of the federal government until 1937, when it was basically tossed out wholesale in the extremely faulty U.S. versus Darby decision in 1941. But this points out another problem, an essential problem with the use of case law, precedent, instead of original intent. Now, in medicine, if you say, this treatment worked for me, they call it anecdote and say, worthless, we want to see the studies. In law, it's called precedent, and they build everything on precedent. But the problem is, if this is the level of the Constitution, and your first decision is here, and the next decision based on it is here, and the third one's here, and the fourth one's here, and the fifth one's here, 100 years later, you're here. But this is your base that you should be judging on. But your decision's up here. Original intent is essential to maintain the Constitution. So this decision, U.S. versus Darby, should not be used as a basis for anything because it is flawed. But if you use precedent, you use flawed decisions to base future decisions. Huge problem. So what powers are delegated to the federal government? We'll see that tonight in the Article 1, Section 8, and a few others. What powers are prohibited to the states? We'll see that again tonight. Where does the federal government's power to protect other states come in? And does the concept of a level playing field, because that's one of the federal government's jobs, is to maintain a level playing field among the states, does that include protection of water, land, and air that crosses state boundaries? Or not? Could that be an area of state control up to and including lawsuits for harm done? And if there's a lawsuit from one state to another state, what court has original jurisdiction? Article 3 tells us that, the Supreme Court. In all cases in which a state shall be a party, Supreme Court has original jurisdiction. So the lawsuit a couple years ago by the feds against Arizona for the horrific infraction of enforcing federal immigration law that the feds weren't enforcing was in Arizona District Court. And we've gone so far away, and our law schools have gone so far away from the Constitution, that nobody on the government side or the Arizona side stood up in front of that judge and said, I move you dismiss under the grounds that you do not have jurisdiction for this case, because it states that in any case in which a state is a party, Supreme Court shall have original jurisdiction. You don't have authority to hear this case, Your Honor. Nobody said that. Nobody. That's how far our law schools have gone from teaching the Constitution. So back to this land, water, etc. What should be the measure for harm done? Reality, conjecture, possibility? What are the costs of inaction in conjecture? And what are the standards for evaluation of conjecture? Can the southern states sue the northern states for using coal-burning plants because it contributes to global warming? What are the standards? And maybe we add in, what's the line between science and religion?